Dear students, hello. My name is Vrinda Bhandari. I'm a lawyer and I've recently just finished my Masters in Law and my Masters in Public Policy from the University of Oxford. Today I'll be teaching you a module on comparative constitutional law, and the specific topic we are going to be discussing is constitutional interpretation by using foreign law. What I plan to teach today is talk about the current landscape of the citation of foreign law by constitutional courts, and then I go on to discuss the benefits of such an approach, the limitations of such an approach, and I end the module by discussing the way forward and looking at how we can present a module on comparative constitutional law. So just to begin with, what is comparative constitutional law? A legal definition, as Ran Herschel put it, is that it is the systematic study of constitutional law, jurisprudence, and institutions across polities. Simply put, this means that while interpreting the country's constitutions, domestic courts use various interpretive devices such as the text of the statute, case law which serves as binding precedent, law journal articles, and also, and which is the focus of this module today, foreign law. The use of foreign law in constitutional interpretation has seen a recent resurgence and has started playing a central role in domestic constitutional adjudication. It has started gaining increasing popularity for a number of reasons, such as the greater constitutional convergence, especially amongst liberal democracies, legal harmonization, transnational governments, and information communication technology developments, which allow increasing access to foreign decisions. However, the increasing use of foreign law in domestic constitutional interpretation has become a source of heated contestation, as we will see in this module, especially in death penalty and LGBT rights jurisprudence. So before proceeding, I just want to go on the characterization of foreign law and what I mean by that in distinction to international human rights law or foreign legal developments. When I talk about foreign law, I talk about it as a source of reasoning, which is looking at the foreign decisions from foreign countries and looking at the source of reasoning in these cases. This is different from international human rights law, which is the practice of citing international treaties, documents, and covenants such as the UN Charter, the Universal Declaration of Human Rights, the ICCPR, and the ICESCR. Again, this is also different from foreign legal developments, which is the practice of considering the trends in foreign jurisdictions, whether they are achieved by legislative or judicial action in the interpretation of domestic constitutional provisions. This module thus looks at foreign law as a source of reasoning in domestic constitutional interpretation. Now moving on to part 2 of the module. Here I'm going to map the checkered landscape, which will look at two things. One, the language of constitutional comparison, and second, tracing foreign citations across different jurisdictions. Coming to the first point, which is the language, what are the different metaphors which various academics and judges have used to describe this practice of comparative constitutional law? People have called it the borrowing of ideas across courts, or as Anne-Marie Slaughter puts it, a judicial dialogue between courts. Sujit Chaudhary talks about it as a migration of ideas across jurisdictions. It's also been called a transjudicial or cross-constitutional influence of ideas across jurisdictions. In this module, I prefer the use of the term influence over, say, a borrowing metaphor, because the borrowing metaphor refers to a unidirectional flow of information, with the implication that the borrowing court only improves upon or modifies the foreign doctrine, which is owned in a sense by the foreign country. In contrast, the idea of influence, which I prefer, across courts and constitutions, contains the possibility of positive, negative, and indirect influence. For example, the Indian Supreme Court, while upholding the constitutional validity of the death penalty in the famous Bachchan Singh case, took lessons from the American post-Furman versus Georgia experience to conclude that the judiciary lacked the institutional competence to articulate the prevailing moral standards or will of the people. I now move to the second part of this section, which is looking at tracing foreign citations across different jurisdictions. Which countries are more open to citing foreign law to aid their constitutional interpretation? In general, Cheryl Saunders argues that common law courts are more likely than civil law courts to cite foreign law. But this is not without controversy. For example, in America, in the famous Roper versus Simmons case, which was about the death penalty for juvenile offenders between 16 to 18 years, holding it to be unconstitutional, Justice Kennedy for the majority said, as you'll see on your slides, it was only proper to acknowledge that the overwhelming weight of international opinion against the juvenile death penalty allowed the court to reach its conclusions. Similarly, in Lawrence versus Texas, the United States Supreme Court relied on the European Court of Human Rights jurisprudence, along with the actions of other nations, to invalidate the criminal prohibition of intimate conduct amongst consenting homosexual adults. However, this has been severely criticized by various judges such as Justice Scalia and Justice Rehnquist, who have said that the court should not give credence to the views of foreigners. In India, the issue is less divisive but is also more unsettled. In Bachchan Singh, we can see the Supreme Court's initial wariness as, and I quote here, about the expediency of transplanting Western experience in our country. But later on, in Santosh Kumar Bariyar, another death penalty case, the court said it could not help but observe the global move away from death penalty, with specific reference to the situation in India's neighbors Nepal and Bhutan. In South Africa, in contrast, which is the third jurisdiction we are looking at, the issue is more settled because of Section 35(1) of the Constitution, which expressly contemplates that while interpreting constitutional provisions, courts shall, and I quote here, have regard to public international law and may have regard to comparable foreign case law. Hence, in the seminal death penalty decision in S versus Makwanyane, the Constitutional Court referred to the death penalty jurisprudence in India, America, Germany, Canada, and Hungary, stating that while we can derive assistance from public international law and foreign case law, we are in no way bound to follow it. The final jurisdiction, from where I'm going to give an example, are cases from the Privy Council judgments, which cite case laws from Commonwealth countries, such as while sitting as final courts of appeals from courts in the Caribbean. For instance, in Pratt and Morgan versus the Attorney General in Jamaica, while determining the role of delay in the execution of the death sentence, the Privy Council cited what it termed powerful arguments from case law in the United States, ECHR, India, and Zimbabwe. So clearly, the citation of foreign law and foreign legal developments in constitutional interpretation is not isolated or an uncommon phenomena. What then drives its popularity? To this part we now turn. This is thus part 3 of the module, which talks about the benefits of citing foreign law. And here I'm going to give you 4 reasons. The first is that foreign law acts as a source of reasoning. What does this mean? This means that an appeal to foreign law serves as a source of reasoning where the focus is on the process by which the foreign courts arrive at their decision rather than the outcomes. Presenting a wider range of arguments before domestic courts and providing them with methodological guidance in applying constitutional standards increases the quality of the court's own deliberations. Thus, even though foreign law may not be a guarantor of truth, it guides the elaboration and development of law, and it uses other foreign decisions to help the domestic courts self-introspect. For example, in Force versus Minister of Safety and Security in South Africa, Justice Cato Regan notes, while the courts must avoid what she calls shallow comparativism, which means comparing uncomparable legal institutions, she says, and I quote, to forbid any comparative review because of those risks would be to deprive our legal system of the benefits of learning and wisdom found in other jurisdictions. I now come to the second benefit of foreign law, which is its confirmatory power. This means that foreign law serves to confirm and strengthen the court's constitutional interpretation. Citing law from other countries improves the quality of legal arguments and helps the court persuade the audience, which are primarily the litigants before it. It also helps the court to persuade the domestic political and institutional actors about the correctness of the decision, which prevents a possible legislative overcoming of the decision or policy outcome. The third benefit, which we are now going to talk about, is a benefit to newer and younger jurisdictions by citing foreign laws. Citing foreign laws allows newer jurisdictions to draw on older and more established democracies to bind their countries to this existing community of states. For example, in the Makwanyane decision we talked about earlier, the court says comparative Bill of Rights jurisprudence will no doubt be of importance, particularly in the early stages of the transition when there is no developed indigenous jurisprudence in this branch of law on which to draw. Thus, post-independence, one should accordingly see greater citation or reliance on foreign law than many decades after independence. This we've seen to be confirmed in India, where an empirical study looking at the constitutional bench decisions across the 50 years since independence saw that constitutional benches were citing foreign law around 71% of the times in all their cases in the 1950s, which then dropped to 61% in the 2000s. I now finally come to the fourth benefit of using foreign law in constitutional interpretation, and this is talking about the lessons learned. This is what Chris McRudden calls pedagogical impulses, which drive domestic courts to learn lessons from the success and failure of foreign courts, or what Kim Lane-Chappell calls aspirational and aversive constitutionalism. An example of aspirational constitutionalism can be seen in Israel, where under Justice Barak, he drew on American case law on the First Amendment to use the American model to facilitate the realization of democratic aspirations. Here we see thus an example where a court has used foreign law as a sort of aspiration of what it wants the jurisprudence of its own country to develop. Conversely, we have aversive constitutionalism. For example, in Makvanyane, the South African Constitutional Court on death penalty says it was discouraged by the endless litigation arising from the development of American jurisprudence, which should not view death penalty as unconstitutional per se, but recognize that in certain cases it might be cruel and unusual. In fact, these resulting difficulties, in the words of the court, persuaded it not to follow this route. Similarly, the Irish Supreme Court was reluctant to follow the path led by the American courts in Roe versus Wade in the controversial abortion decision, while deciding their own abortion case in McGee versus the Attorney General. On a related note, along with foreign law as a source of reasoning, even foreign legal developments assist domestic courts in evaluating the validity of claims before it and conducting empirical as opposed to normative inquiry. For instance, in the famous Delhi High Court decision of Nas Foundation, the state argued that the legalization of Section 377 would have two problems. One, it would have adverse public health and HIV/AIDS consequences, and it would, in the words of the state, open the floodgates of delinquent behavior. On the first argument regarding public health, the Delhi High Court cited the Human Rights Committee's conclusions in Toonen versus Australia to say that no link had been shown between the continued criminalization of homosexual activity and the effective control of the spread of the HIV/AIDS virus. Similarly, while responding to the floodgates argument, the court said, and I quote, "It is not founded upon any substantive material, even from such jurisdictions where sodomy laws have been abolished." So as we see, reference to foreign law may be helpful when domestic law is either new or unsettled. But, and this is what I'm going to move on to next, it is problematic when the law is relatively settled or the domestic context is vastly different. This then is part 4 of the module, which talks about the potential pitfalls in the citation of foreign law. Here, I talk about 3 such pitfalls, which are concerns arising from legitimacy, competency, and methodological issues. Coming to the first part, which are the legitimacy concerns of the court. While we start this, we should first understand that the value-laden nature of constitutional interpretation, the impact of human rights cases, and the judicialization of politics has meant that comparative constitutional law should not diminish public confidence in the administration of justice. However, its critics, such as Justice Scalia in the American Supreme Court, charges judges with eroding the legitimacy of the democratic courts by undermining democratic consensus and sovereignty, because domestic courts are then purporting to impose the views of foreigners. We can even look at Chief Justice Rehnquist in his dissent in the famous Atkins versus Virginia case on the death penalty, where he says, and I quote here, "I fail to see, however, how the views of other countries regarding the punishment of their citizens provide any support for the court's ultimate determination." So, this legitimacy objection thus rests on a democratic objection and an American exceptionalism argument. The democratic objection rests on a separation of powers argument that unelected domestic judges should not introduce the views of unaccountable foreign judges into law. As Justice Scalia says, and you can see this on your screens from which I'm quoting, I dare say that few of us here would want our life or liberty subject to the disposition of the French or Italian criminal justice, not because those systems are unjust, but because we think ours are better. What reason is there to believe that the dispositions of a foreign country are so suitable to the morals and manners of our people that they should be judicially imposed through constitutional adjudication? A second strand of this legitimacy objection is an objection which is placed especially in American courts due to the American exceptionalism. This is the belief that the United States does not share any common enterprise with any other legal polities. This we can see in the Stanford versus Kentucky case, where in his dissent, Justice Scalia, while rejecting the relevance of the fact that no other country imposes the death penalty on juvenile offenders, emphasized that in fact it was the American conception of decency which was dispositive. Now I come to the second concern which has been levied against the practice of comparative constitutional law, and this deals with the issue of competency of courts, or what we earlier termed shallow comparativism. This arises when there are careless transplants of foreign legal concepts developed in distinct political, cultural and institutional environments. For instance, Justice Sarkaria in the Bachchan Singh case in India says, and I'm quoting here, social conditions are different and so also the general intellectual level. Arguments which would be valid in respect of one area of the world may not hold good in respect of another area. His fears we see come true in a different context in America in the famous case of Prince versus the United States, where Justice Breyer very controversially conflated the European Union model of federalism with the US federal structure. And hence, instead of looking at two common legal problems affecting a common system, in fact, he ended up looking at two very different and distinct legal systems. This then is the competency concern. I now move on to the methodological concern, which forms the third strand of the potential pitfalls of comparative constitutional law, and deals with the issue of cherry picking. Cherry picking refers to the practice where judges refer to only those foreign norms that sit comfortably with their own moral preference. This then erodes the distinction between moral reasoning and what is very distinctively legal reasoning. So judges then are allowed to cite decisions from select foreign jurisdictions or civilized countries. They can instead have selective citation within a particular jurisdiction, or they can just cite a dissenting opinion amongst a plurality of opinions. Justice Posner articulates this criticism well when in his foreword to the Harvard Law Review, he writes, "Foreign decisions are freely citable. Any judge wanting a supporting citation has only to troll deeply enough in the world's corpora juris to find." We see his concerns come true to some extent in the European Court of Human Rights case in Öcalan versus Turkey, where the court, looking at whether the developments in comparative law had shown that death penalty had become contrary to the international law in the context of the European Convention, only cited examples of the abolitionist countries such as South Africa, Canada and Hungary while evaluating its stance. However, while doing so, it ignored the stand in countries such as America and India, countries which have retained the death penalty. We thus see a cherry picking of the countries from which foreign decisions are being cited. While American courts seem content to rely on foreign law, although note only European law, in cases such as Lawrence versus Texas, they say, and I quote, "Not a whisper about foreign law when it comes to abortion cases such as Roe v. Wade, where foreign law does not support their conclusion." In fact, in a very powerful dissent in Roper versus Simon, Justice Scalia says, and I'm quoting here, and you can see this on your screens as well, "The court should either profess its willingness to reconsider all these matters in light of the views of foreigners, or else it should cease putting forth foreigners' views as part of the reasoned basis of its decisions. To invoke alien law when it agrees with one's own thinking and ignore it otherwise is not reasoned decision making but sophistry. Cherry picking, thus, another related element of it, focuses on only pioneer jurisdictions or successful jurisdictions, and hence the court is then trying to construct a progress narrative. For instance, in Lawrence versus Texas, the dissent criticized the majority's decision to rely on only decisions from the European Court of Human Rights jurisprudence to overrule the existing Bowers versus Hardwick case, which in fact had held that homosexual sodomy was criminalized, while ignoring the rest of the world, which was, in their words, pretty divided on overturning criminal prohibitions on sodomy. This then, I have shown you here the three major concerns with the use of foreign law in constitutional interpretation. It was, and just to recap, a legitimacy concern, a competency concern, and a methodological or cherry-picking concern. Moving forward, I go to my last section, which is on looking at constructing a suitable comparative constitutional discourse. Just as judicial discretion is justified by the requirements of giving reasoned decisions, constitutional comparison requires courts to address from which countries they have cited foreign law, when they cite foreign law, and thirdly, what weight they should assign to such comparative arguments. Coming then to the first point, which country, or in other words, what foreign law are we talking about? Here, I'd like to talk once more about changing the metaphor from borrowing to influence, because as I had discussed earlier, borrowing signifies a certain unidirectionality in the citation of foreign law, which seems to replicate global economic and power structures. Thus, it seems that only some countries are always borrowing foreign law from other countries and not vice versa. We see this in the practice of developed or Western countries citing foreign law only from other such developed or Western countries. For example, in America, in the majority's observations in Thompson versus Oklahoma, where they concluded that it was unconstitutional to give death penalty to juveniles under 16 years, the court noted that their conclusion is also consistent with the views expressed by respected professional organizations, by other nations that share the Anglo-American heritage, and by the leading members of the Western European community. Similarly, another related aspect to this practice is countries in the global south being more inclined to cite foreign law from countries in the global north rather than other global south countries. The empirical study I had mentioned earlier, where we looked at the constitutional bench decisions since independence to the 2000s in India, showed that the highest proportion of foreign law which was cited by the constitutional bench was from England. It was 51% in the 2000s, followed by the United States, which was 36% of all foreign law cases, and then the other jurisdictions such as Australia or Canada. In fact, even most of India's public interest litigation jurisprudence, which was created, was crafted through a creative reinterpretation of Article 21, citing primarily American law. In fact, it is a trend in Indian courts that we do not cite laws from decisions from Pakistan, Bangladesh, or Sri Lanka, even though they are our neighbors. This is changing, albeit slowly. For example, in the High Court decision in Nas, we saw the court cite cases from countries far and wide, such as Nepal, Fiji, and Hong Kong, alongside obviously America and England. This inclusive comparativism, as it has been termed, successfully employed foreign law to demonstrate the geographic neutrality of certain values, as Madhav Khosla argues, and show that homosexuality is not a purely Western construct. Thus, by citing cases from these countries far and wide, the court was able to deconstruct and diminish the state's arguments that homosexuality was a very Western and British concept. Other examples include Pakistan and Bangladeshi courts citing jurisprudence from the Indian Supreme Court while developing their own public interest litigation jurisprudence. In fact, and in the paper I have talked about this in detail in the footnotes, there is a lot of cross-citation between India and South Africa, two global south countries, in cases of death penalty, housing, and emergency medical treatment. What is the advantage of this inclusive comparativism? Having a wider variety of jurisdictions to choose from compels domestic courts to give more content-dependent reasons for preferring one set of foreign cases over another, and reduces the importance of factors such as socio-economic power, foreign policy, or reciprocity. Now coming to the second strand of this section, I talk about the appropriateness of citing foreign law, or rather trying to answer the question of when one should cite foreign law. Here I rely on Sujit Chaudhry's three modes of interpretation: the universalist, dialogical, and genealogical interpretation of comparative constitutional law. The universalist model normatively justifies comparative citation on the basis of the existence of universal norms which are identified and interpreted and applied by constitutional courts across the world. They are premised on the idea that human rights are universal and not society specific or local, and hence they can transcend territorial boundaries. We saw this in Roper versus Simmons, where the Supreme Court of America said, "It does not lessen our fidelity to the Constitution or our pride in its origins to acknowledge that the express affirmation of certain fundamental rights by other nations and peoples simply underscores the centrality of those same rights within our own heritage of freedom." This universalist model is thus relatively uncontroversial when talking about universally held norms such as dignity or the right to life. Unfortunately, it is not as useful while dealing with contested issues such as abortion or gay marriage, where critics are wary of importing global norms at odds with local norms. We saw this in Thompson versus Oklahoma, where the dissenting opinion noted, where there is not first a settled consensus amongst our own people, the views of other nations, however enlightened the justices of this court may think them to be, cannot be imposed upon Americans through the Constitution. Coming now to the second model, the dialogical interpretation. This uses comparative constitutional law to self-introspect and see the normative and factual assumptions underpinning our legal system. It thus provides an outside lens for improving the insider view or a new way of thinking about old problems. Sujit Chaudhry justifies the use of foreign law using this model in the Nas decision, where he said that comparative constitutional law was used not by asserting it to be true or right, but to rather revisit and extend the premises of the Indian Constitution to conclude that it could be interpreted in a manner which was consistent with the decriminalization of homosexuality. A third model which justifies the use of foreign law is genealogical interpretation, which is using foreign law when there are common alliances between countries which share a common or historical past. So we see this in Indian or Caribbean courts, and they are more likely to cite cases from England than from any other country, including even America or Australia. I now come to the final part of this section, which is talking and answering the question of what it means to use foreign law, the title of this topic, the title of this chapter, and understanding its influence. This module does not argue that comparative law requires a blind migration of ideas, nor does it expect foreign law to be controlling. Instead, the module argues for a confirmatory role of constitutional comparison, or what has been termed a soft use, where foreign law is not binding on domestic courts. Here, foreign law, or more specifically, the reasoning of foreign appellate courts, though lacking in precedential value, is used for its persuasive power. As we saw the South African Constitutional Court used so in Makwanyane, the death penalty case, where the court said that while comparative law was persuasive, given that the indigenous jurisprudence was still developing, it was not decisive. Hence, I argue that we should cite foreign law only for content-dependent reasons, as Madhav Khosla had articulated them, and not for reasons of geography, socio-economic power, reciprocity, or foreign policy. This practice drives judges to justify their citation of foreign law and acts to curtail their judicial discretion. For example, in Lawrence versus Texas, the American court justified its reliance on foreign law as exposing the flawed assumptions in Bauer that the West was united in condemning homosexuality. It noted, To the extent Bowers relied on values we share with the wider civilization, it should be noted that the reasoning and holding in Bowers have been rejected elsewhere. Similarly, in Bauer, the court had said, decisions of individuals relating to homosexual conduct have been subject to state intervention throughout the history of Western civilization, and condemnation of these practices is firmly rooted in the Judeo-Christian moral and ethical standards. Hence, we saw how Lawrence versus Texas relied on comparative law to expose these flawed assumptions. So then, what have I told you today? I have shown you, I have tried to map the landscape of how foreign law is used in constitutional interpretation. We started out by looking at certain metaphors and what was the language of foreign law. We then looked at certain jurisdictions where foreign law has been cited and what the courts have to say about that. Part 3 then went to the benefits of citing foreign law, where I traced 4 reasons. Foreign law is a source of reasoning, the confirmatory power of foreign law, the benefits to newer and younger jurisdictions, and the lessons learned. In part 4, I talked about the 3 concerns which are raised and the potential pitfalls of citing foreign law, namely the legitimacy concern, the competence concern, and the methodological concern. In the final chapter, I looked at how to construct a suitable comparative constitutional discourse, and where I was looking to see from which countries we can cite foreign law, when we should cite foreign law, and what reliance should we give to foreign law. I have basically argued that courts should focus on value transparency instead of value neutrality, because constitutions do not operate in vacuum. Constitutional interpretation has social and political undertones which are only magnified by the decision to rely on foreign case law. Hence, I hope this module has been helpful to you. Thank you so much.